Mr. Church, Mr. Woodward, for the plaintiff, Mix Parsons, Mr. Epping for the defendants. We have two motions today. A motion by unnamed persons to have claims against the unnamed, unidentified persons dismissed, and then a motion to dismiss for lack of service as to the unincorporated associations. Next Parsons.
Thank you very much, Your Honor. First, with respect to the motion to dismiss on behalf of the John and Jane Doe parties, in light of the plaintiff's amendments to the verified complaint that were submitted last week, he has since identified those individuals in compliance with Rule 10D, and so we're not going to pursue that motion for the purposes of this hearing. But we do still want to move forward on the motion to quash with respect to the 4 unincorporated nonprofit associations. I don't want to rehash the briefing too much here. I think that the gist of it is that the plaintiff has just served every individual in this action with copies of the summons and the complaint on the assumption that one of them might be a manager or otherwise a person who is authorized to accept service on behalf of those entities. As our briefing discusses, the mere fact that he has served all of these individuals does not mean that he has properly served these entities. He doesn't allege at any point or identify any of these individuals as being individuals who are authorized to receive service or process. And under the Elliott versus Verska case that we rely on in our memorandum, that's just not proper service or process. Even if some of those individuals are members of these unincorporated associations, their mere membership in those groups does not automatically mean that they are authorized to accept service on their behalf. Moreover, the only entity that the plaintiff asserts that he has even served a member of is the People's University itself. First off, that's not what the protest has been referring to itself as. It has been referring to itself as the People's Liberated University. And while that distinction seems minute, I think that precision with respect to the entities that they're attempting to serve is crucial. Second, the only record evidence that they rely on in order to try to establish that they have served an individual authorized to accept service or process are 3 declarations that were filed in Waters versus Little. Those declarations only assert that the individuals served are associated with those groups, and there's nothing in those declarations that suggests that they are authorized to accept service, and the plaintiff doesn't provide any record evidence to support that claim. With respect to the other 3 entities, the Friends of Idaho, Boise, BSU Students for Palestine, and Boise to Palestine, the only argument that they really make in reply is that they had actual notice of the July 15th hearing, that somehow constitutes proper service or process. As discussed in our reply brief, the only case law that the plaintiff relies on in support of that proposition concerns service of process in the context of the bankruptcy regulations. It doesn't concern constitutional service process, and it doesn't concern the rules of civil procedure for the state of Idaho. So that's kind of the gist of our argument, and I'll end there unless the court has any questions.
So the statute regarding service of unincorporated associations appears to be more restrictive than the rules for service on corporations generally. A corporation who has failed to designate a registered agent or failed to authorize someone to accept service or process can be served simply by mailing the complaint and summons to their last known address. What happens when an association doesn't designate an agent, doesn't authorize any of its members to accept service on its behalf, and doesn't have an address?
I think that speaks to a core problem with respect to the entities that the plaintiff is trying to serve in this case. Friends of Idaho, for instance, as far as I understand, is essentially a Facebook page, or an Instagram page, rather. So I think that you're exactly right, Your Honor, that there's not an address or even really a membership list on whom that they could serve process here. For the purposes of this argument, I think what I would say to that is that it's the plaintiff's obligation to engage in the investigation and the discovery that he needs to in order to identify what individuals are managing and making decisions on behalf of these entities, if they're even entities in the first place. So just because they haven't designated, somebody who's authorized to accept service of process or designated a registered agent, insofar as any of these are some type of actual entity, presumably there would be people within them that are making decisions on behalf of the groups, and that would be the proper person for the plaintiff to serve.
All right. No other questions, Mr. Parsons? Thank you.
Thank you very much.
Mr. Woodward?
Thank you, Your Honor. And Defendant's counsel, I think, just made a key, in response to your question, made a key admission that there is no way for these entity defendants to be served, as the court's noted. And we did name them as unincorporated associations, as the court noted. And you referenced the section on service, and that's Idaho Code 30-27-111. And that allows us to serve on either an authorized agent or a manager of the association. And as the court noted, there is no, they're not registered with the Secretary of State. We don't have an authorized agent, but we can serve a manager, and we did. And manager, it's defined by Section 30-27-102A3. And that is, a manager is, quote, a person that is responsible, alone or in concert with others, for the management of the unincorporated nonprofit association. And so, with respect, as we point out in our papers, the People's Liberation the People's University, I'm falling into the same confusion. And Defendant's counsel said that it's not the People's University, it's the People's Liberation University. But I will point out that, and I'll talk about these in a little more detail, the two declarations that Lauren Manuel and Hannah Tucker both filed in their defendants. They both said in paragraph 1, I am involved with the People's University. It's not People's Liberation, it's the People's University, and that's who we served. And both Ms. Manuel and Ms. Tucker are their manager. We serve them as manager on behalf of the People's University. And in their reply, the defendants, they give short shrift to the declarations of Ms. Manuel and Ms. Tucker. They only cite to paragraph 1, which both of them say that they're involved with. But the declarations are actually much more involved than that, and I wanted to point out a few of those provisions. Ms. Manuel's declaration is Exhibit B to my declaration. And in paragraph 2, she says, before we established the People's University on the grounds of the Capitol Annex, I and other people in our group have attempted to reach legislatures to communicate our message. You look at paragraph 6. She says, on May 3rd, 2024, we erected tents on the site of the Capitol Annex. And it includes, those tents are crucial to our demonstration and the core message of our group. I would go to paragraph 10, when we established the vigil site on May 3rd, 2024. And then turning to Ms. Tucker's declaration, she has the same paragraph 2 that Ms. Manuel does. Before we established the People's University, I and other people in our group attempted to reach legislatures. Paragraph 4, on May 3rd, 2024, we erected tents. And again, like Ms. Manuel, those tents are crucial to our demonstration and the core message of our group. Paragraph 6, she states that we have had several conversations as a group about the importance of not sleeping on the grounds. And so the actions that are described here go far beyond just being somehow involved with the group. You've got admissions of establishing the People's University, the decision to erect tents and where, the decision to establish the vigil site in the original instance, and then having conversations as a group about what activities can and cannot be taken on the grounds. And that is clear evidence then that Ms. Manuel and Ms. Tucker are responsible for the management of the People's University. And I think it's also important to note, Your Honor, that nowhere in their papers do the defendants deny that Ms. Manuel or Tucker are managers. And since they both were served with a summons and complaint on behalf of the People's University, and given the activities they've undertaken and the decisions, the managerial decisions they've made, then service was effective on that entity. Now, with respect to the remaining three entities, as the court can see from the Instagram post and the other social media we cited, those three are integrally and interrelated with the People's University. In fact, they collaborated with each other, all four of the entities did, on an Instagram post regarding the July 15th preliminary injunction hearing. And just this morning, Boise to Palestine posted on their social media a call to show up at this hearing today. We did serve all of the individual defendants. We served them individually and on behalf of the four entity defendants. And we did that, as the courts noted, because we don't have any other way of serving them. There's nobody admitting to being responsible. There's nobody we can serve registered agent at the Secretary of State. And so that broad net that we cast, it succeeded because the social media posts I just referenced, they're aware of the lawsuit. The managers are. They posted on it. And I wanted to cite to Renova Energy Corp., and that's a case that's cited in the defendant's papers. And they are interpreting Rule 4H1B, the federal rule there, which allows service of a summons on an officer, managing or general agent, or other authorized agent by law. But what they cite there, the Renova Energy Corp. Case cites direct mail specialists, a Ninth Circuit case. And it says the Ninth Circuit has concluded service is not strictly limited to such categories of persons. Quote, service can be made on a representative so integrated with the organization, he will know what to do with the papers. And as I just said, that's what we did here. We served all the individual defendants in an abundance of caution as representatives of the four defendants. And that succeeded because the managers of those sites, they got the lawsuit, they understood it, and they have tried to rally support here for that. So we feel like we've successfully served definitely the People's University and the other three. And I would just conclude with that to the extent that the court feels that we haven't properly served the defendants, other than the People's University, we have time. We have 182 days to serve them. And so, as we cited in our papers, the proper remedy, should the court feel we haven't properly served them, would be not to dismiss the case, but to quash summons, and then we would still have discovery and other remedies available to identify the managers and serve them. Unless the court has questions,
I do not.
Thank you. Thank you, Your Honor.
Ms. Parsons, any reply?
Thank you very much, Your Honor. I just want to address a couple of things that Mr. Woodward said specifically. First off, Mr. Woodward claims that there is no way for these entity defendants to be served in any instance. I clearly think that there is. They just have to be able to, the plaintiff just has to be able to provide record evidence that the individuals that they are serving are managers of those entities. As Mr. Woodward noted, that's defined as a person that is responsible, alone or in concert with others, for the management of an unincorporated nonprofit association. But the references that he makes to the declarations don't establish that. He's correct that there are places in Ms. Tucker and Ms. Manuel's declarations that refer to the group as the we, implying that they're a part of it. He's correct that there's discussions that are happening within the group, but nowhere in those declarations does it say that Ms. Tucker or Ms. Manuel were making those decisions, merely that the group was making decisions as a whole. Moreover, it's not the responsibility of an entity to step up and tell a plaintiff how to sue them. Again, if Mr. Woodward wants to engage in the investigation and discovery necessary in order to establish who is a manager of this association or who makes decisions on its behalf, then he's certainly welcome to do that. But until then, I think that I agree that the appropriate remedy is to quash the summons for the moment. With respect to his reference to the Renova Corp text, Idaho hasn't adopted that test. As Mr. Woodward notes, that's a federal case interpreting federal law. But we think you should prefer the Elliott versus Verska case that we provided, because that's an Idaho Supreme Court case that's interpreting Idaho's Service of Process rules itself, the 43. So his reference, his attempt to use that case in that way is inapposite. I think that's what I wanted to address from what he said, so unless the court has questions, I'll end there.
Thank you.
Thank you, Your Honor.
Well, I think in any service of process questions, there's a constitutional question and there's a statutory compliance question. Those can be distinct depending on how the legislature has set rules for serving a particular individual or serving an entity. Here, reasons I can't guess at, it does appear to me that the legislature has made it more difficult to serve unincorporated nonprofit associations than the legislature then is. I guess I'll say it. It's less difficult to serve corporations than it is to serve unincorporated nonprofit associations. I don't know why that would be, but that appears to be how the statute is written, because you can't serve an unincorporated nonprofit association by simply mailing this complaint and summons to their address when they haven't identified someone who's authorized to accept service. Nonetheless, the rule requires service on a manager or person authorized to accept service. The responsibility is on the plaintiff to establish proper service. This motion is backwards in many respects, and I say it this way. Generally, individuals who are being sued are the ones asserting that they are employees or agents of a corporation, or they are members of an unincorporated nonprofit association, because being a member or an employee in the corporation shields them from individual liability for their actions in the course of their employment or their course of membership in the not-for-profit association. And so generally it's the individuals being sued who are asserting a claim that you can't sue me, you have to sue the not-for-profit association. Because not-for-profit associations, if they exist, limit the liability of their members. They can own property and conduct business under the law, just like other corporations. And so I think that's one reason why this doesn't come up very often, where we have somewhat the inverse, where a bunch of individuals who are being sued aren't raising this issue as somewhat of a defense. Perhaps the plaintiff believes that these associations own lots of property, and that's why it's necessary to get a judgment against the associations. I don't know. It's just unusual where the plaintiff is seeking to sue a company. That said, here's, I think, how this works. Are these unincorporated nonprofit associations? Don't know. But that means an unincorporated organization consisting of 2 or more members joined under an agreement that is oral or implied from the conduct for one or more common non-for-profit purposes. Certainly the pleadings are that these entities fall into that definition. I think that's sufficient for this purpose. Then the question is, if you want to serve that, you have to serve a person who is responsible alone or in concert with others for the management of an unincorporated nonprofit association. I will note that the legislature seems to have presumed, or perhaps required, that in order to be an unincorporated organization, you have to have established practices and governing principles. That seems to be how the legislature has distinguished members of a non-for-profit associations from managers of a non-profit association, because the member is somebody under the governing principles of the organization who can participate in the selection of the managers. And the managers are the people responsible for management. Thank you for that highly useful definition of the organization. And so it does appear to be that there's an assumption that this is an organization in order to be able to, one, own property under the law, and two, shield your members from liability for their conduct. There does appear to be some expectation or perhaps requirement by the legislature that you have governing principles, that you have established practices, that you have members who vote for managers, and then you have managers for who make decisions about the not-for-profit association. And that can be as loose as, the bingo league at the church that raises money to donate to the food bank, or the dog rescue society, or the woodcarvers guild, or something else. But there has to be some internal practices. I don't have any evidence to suggest that any of these entities are that they are anything more than a loose association of people who have banded together under a common name. But I don't think I need that for this motion. I think I have to simply take as true that these are unincorporated nonprofit associations, because that's the claim. Certainly, I guess one of their defenses to this claim can be, you can't sue us because we're not an unincorporated nonprofit association. I think that's an issue for later down the line. Here, the question is whether, assuming they have these kind of established practices, that they have these governing principles, that they have managers and members, whether there was service upon a manager or somebody else who was authorized to accept service on behalf of the association. I can certainly infer that from conduct. I can infer that from testimony. I don't think I need an admission that I am a manager. As for this motion, I'm willing to make that inference as to the People's University. As to the name issue, well, if the plaintiff has decided to sue the People's University, if that is an entity that's distinct from something else, using liberation in the name, well, then perhaps they've not sued who they want to sue, but that's who they've sued. And so my question is simply whether they've properly served the People's University, assuming that exists. And I'll conclude from the declarations of Ms. Manuel and Ms. Tucker that they are managers and they have been personally served, and so therefore the People's University has been served. As to Boise to Palestine, Friends of Idaho, and BSU Students for Palestine, I don't have that kind of testimony. I'm not willing to infer that from Facebook posts or internet calls to gather people to come to these court proceedings. That doesn't tell me much, if anything, about whether or not who's making decisions for the organization as a whole. And so I'll quash the summons as to those. Given that there's time for those entities, assuming they exist, to be properly served, I'll decline the motion to dismiss claims at this juncture. Anything else?
No, Your Honor.
All right. I'll get an order in writing to that effect. We're in recess.